Hypocrisy.
Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I'm your really late host, Nick Rekieta of Rekieta Law, small law firm in central Minnesota. And I do apologize, guys. I was, my son is like me, but he's also way better than I am in a lot of ways. And the way he's like me is doing everything at the last possible second. The way he's better than me is he was applying for the National Honor Society, which is due tomorrow. And of course, having to finish everything tonight, which means writing a personal statement, listing all of his cool little achievements and everything. And I'm like, bro, go to bed. Oh my God. But he had to get it done tonight. So I was helping him out. My apologies for that. I was not planning on it taking an extra half hour. But it did. So anyway, we are going to cover some crazy, well, not really that crazy. We're going to cover a couple topics tonight. Law topics, really. The first one's kind of funny. This is a diversity, equity, and inclusion lawsuit, but the other way, though, right? Going the other way. It's brought by a conservative. Actually, the guy who got DEI taken out of college admissions, oh yeah, he's on a warpath, and now he's going after all sorts of other DEI initiatives in private companies. And the best part is the law that he's using to go after it was written in 1866, and it basically says that you can't discriminate in favor of whites. And he's now using DEI, or he's using this law preventing discrimination in favor of whites in private companies to go after all of the other discrimination due to how that law has been interpreted and utilized following the 14th Amendment, where any protections for anybody based on anything have to be applied to everyone, which means that if it's a pro-black, for example, as this law was typically in 1866, a pro-black law that you had to contract with black people equally to whites. Now, under the 14th Amendment and the subsequent jurisprudence around it, that means that you have to contract with whites equally to blacks. Well, there's a bunch of organizations that give grant money specifically to black people and a lot of times black women. Now, this is kind of covered in Title VII, the Civil Rights Act of 1964, which we're not going to go into. And I'm way over explaining the intro to this topic, but it's kind of covered there. But there are different requirements here. There's a heightened standard, but no cap on damages. And it's really funny to just see how a creative use of a law that was to prevent the favoritism towards white people is now going to be used to go after diversity, equity, inclusion, because equality is a motherfucking bitch. Isn't it? So we're going to do that. And then we're going to talk about this federal judge down in Georgia who said, why don't you like black people? There's a lawsuit raised in Georgia. So Georgia's trying to tighten up its early voting window. Mainly because there's a real disaster if they do their runoff elections. Georgia's like the only state that does the runoff elections the way they do. And it's why Georgia can take weeks and weeks and weeks to be decided in a presidential election where everybody else is done much earlier. Well, there's a way that due to early voting registration that would allow you to not vote in the general election, but then register and vote in the runoff election, which doesn't seem like a good thing to do, right? If you didn't vote in the general, should you be able to vote in the runoff and be the deciding vote? Or, I mean, can they just find some people to register? They would never do that. That's crazy. Stop talking like that. But they don't want that to happen anymore. So Georgia tightens up the voting window so they can't do that. Now, in doing so, in tightening up that voting window, Democrats got mad and sued them saying, but black people can't follow timelines. You can't do this to them. They don't even know what calendars are, which I think is a little racist. I'm not sure about you guys. I think that's a little racist. And the judge ruled on this today. So we're going to see how the judge ruled on that lawsuit. And then finally, Trump is in court again, this time being sued again by E. Jean Carroll. And the judge is having a goddamn conniption because every judge who has to deal with Trump that he didn't appoint has a goddamn conniption because they all hate him. They all hate him quite a bit. And now this judge is threatening to throw Trump out of the courtroom because he just can't control himself. There's some other aspects to this that we'll get into, and there's maybe a little more on the Trump front that we'll have to talk about. But ultimately, this is just a Trump date, and it's going to be involving primarily this E. Jean Carroll lawsuit and then a couple other things. Now, we're going to get started on that really quickly. We're going to get right into the topics. I don't know that we're going to go super long tonight. I was not feeling well yesterday night. I just passed out. The people who saw my locals post noted that like it was unintelligible at parts because I was still literally asleep while typing it. And then this morning I woke up still not feeling the greatest. So probably going to be a little shorter stream tonight. And I feel okay, but still a little weird. Just feel weird. Maybe it's the latent homosexual. No, I just feel weird. That's what it is. So we'll probably cut it a little bit short tonight. May do some stuff in the morning or tomorrow during the day. I don't know. Depends on how the day pans out, but I'm trying to get like back into a good rhythm. But right before we do that, I just realized I need to grab something real quick. So I'll be back. You can listen to or look at Mohammed Anna Kasparian for just a minute and Allahu Akbar. We'll be right back. Face east, always towards Mecca. All right. Sorry about that. Fun delays. Okay, here we go. Let me get to this first topic. Oh, and by the way, Daniel Perry, Daniel Perry, I think. Let me get his name right. What a jerk. The Subway Strangler. I don't want to. I think it's Daniel Perry. Anyway, his case is moving forward. He tried to have it dismissed on self-defense grounds from a legal standpoint. Didn't work, probably because he's white. But that being said, his case is moving forward. I'll be following Penny. It's Penny. Damn. I had two chances, and that was not it. He tried to have it dismissed on self-defense grounds from a legal standpoint rather than from a jury decision, and it did not work. The judge said, nope, it's going to move forward. So we'll be following along with that case as it develops and eventually goes to trial. And that will be a trial to watch for sure. That's one that's going to have the nation's attention. So that'll be good. We're going to go, you mean the victim? Yes. Yeah, actually the victim specifically of the system. I actually, it's a weird thing. His case, let me pontificate for a second. If I may, if I'm allowed to do that, can I do that? Who do I have to ask permission for to do that on my show? It's a weird thing because I do have compassion for the guy who died, but I don't think that Daniel Penny is to blame for it. I mean, he's the instrument by which the death occurred, but it's not like he was trying to kill the guy, and I don't think he acted improperly from what I've seen. Now, maybe they've got some crazy footage that shows some way in which he's more responsible for the killing than we're aware. I don't think so. I feel like that would have come out by now. But this idea that you can act in a way to restrain someone, to keep people safe, someone ends up dying during it, not intentional. It doesn't look like the restraint was overly applied or improperly done or some negligence occurred, just that this guy ended up being susceptible to this thing and would not settle down in the meanwhile. This guy's out there trying to protect people. This person ends up dead. I feel bad for the dead guy. Like, sucks that you're dead. I wish you were alive and not crazy. That would have been better. But now this guy, Daniel Penny, he has to bear the brunt of this. First of all, it's a public humiliation campaign. He is now the media's target. I mean, he was from the moment of the death. That's what I'm saying now. He's the media's target, and he is their punching bag, just like Kyle Rittenhouse, just like Officer Michael Brown. Not Michael Brown. Michael Brown wasn't the officer. Officer Darryl. The guy who shot Mike Brown. Hands up, don't shoot. Except me, motherfucker. What was that guy's name? Darren Wilson. Mark Zimmerman. These are people who ended up acting properly, but the media distorts the story and then makes them into their villain for their clicks, for their blood clicks, right? Because they're not actually good at getting people's attention without utilizing someone else and vilifying them. They distort the truth specifically for their own ratings, and then they don't care about the wake that's left behind, usually because their ratings match their political agendas as well. So this guy is now agendized as a murderer and will be labeled as such throughout his entire trial, and he'll remain labeled that long after, and he will have troubles in life. He'll have troubles getting work. He'll have troubles getting, entering various social circles. He'll have troubles wherever he lives and moves. If people find out, he's going to have to work to obscure who he is and where he is for the rest of his life because of the media campaign against him, even if he's found completely justified in what he does. We've talked to Kyle Rittenhouse a couple times, and man, like Kyle's got in some aspects kind of this cool, interesting thing where he's got a book and he's moving around and going on these shows, and like he gets to go on Tucker Carlson and stuff like that. But that's not life. Those are moments. The rest of the life is worrying about everything you do, is worrying about, does somebody know who I am? Does somebody have the wrong view of me? Does somebody hate me for staying alive that day? That's what these people have to deal with. And it really is fucking irritating to me because the distortion from the media and their thirst for rivers of blood in the streets so that they can sell just one more click and one more ad placement mislabels these people for their entire lives. So that's it. Thanks for coming to my TED Talk. All right, here we go. DEI opponents are using an 1866 civil rights law to challenge equity policies in the workplace. Now, you may think that an 1866 civil rights law is just the N-word written over and over, but it's not, although that would be kind of funny. But this is good. I love this story because this is an unorthodox approach to law. Something Gosney said about me last night, if I could talk about myself, was that ideal in the abstract, in this like concept of issue spotting and then taking on alternative ways of approaching these scenarios, because there's the regular ways that people look for, but then there are these alternative sort of approaches, either constitutional philosophical arguments, or in this case, using historic statutes that have lingered around for no real reason, because we have replacements for this type of stuff. But these statutes have hung around, and now applying them completely differently, but in a proper way. So here we go. Opponents of workplace diversity programs, that's me. I'm opposed to workplace diversity programs, are increasingly banking on a section of the Civil Rights Act of 1866 to challenge equity policies as well as funding to minority-owned businesses. Section 1981, good year, of the act was originally meant to protect formerly enslaved people, or black people specifically, from economic exclusion. Well, I mean, I guess it actually wasn't formerly enslaved people. It was literally black people, because formerly enslaved people included non-black people, but this is about black people specifically. So in this case, their or was right, and their formerly enslaved was wrong. The timing hints towards the end of slavery because it's 1866. However, it's literally about black people because it's not former slaves. It's directly referencing whites versus others. And in this case, others would be black. But now the American Alliance for Equal Rights, AAER, a group run by Edward Blum, the conservative activist who challenged affirmative action in higher education and won, is citing the section to go after a venture capital fund called the Fearless Fund, which invests in businesses owned by women of color. And that's kind of interesting, right? The Fearless Fund. Can you imagine a grant program that was for white men? Hypothetically speaking, how do you think that would go today? I don't think it would do too well. I don't think it would do that well. Wait a minute. Tommy Gunn says, pause. Tommy Gunn says, Uncivil Law went on Destiny's show and did horrible arguing against Destiny about January 6th. And you and Robert Barnes should go on Destiny's show and debate Destiny and Pisco. Well, debating Pisco is pointless. I already talked to Destiny about January 6th. He didn't seem to follow the thread. I wonder what, I'll have to maybe go ahead and watch that. Be curious to see how that was. I don't know if I love Kurt. I don't know if he is the right style to discuss things with Destiny. But anyway, back to this thing. Can you imagine? Now, my grandfather was a chemical engineer. He got his engineering degree from Rice University, a fantastic school. But Rice University was set up as an all-white scholarship-only school. And so Rice used to be only for young white men. I mean, the guy who established the school and dropped the the giant foundation, the foundational donation for it that kept the school going. It was a whites only, scholarship only school. And now like they stopped that and they had to give the money back to the estate of this long dead guy, I believe, when they decided to switch to be, to enroll everybody else. And now anybody can go to Rice, but at the time that's what it was. But can you imagine anything like that anymore? It would, first of all, it'd be burned to the ground. It would be torched and burned to the fucking ground. But second of all, there's no way anyone would let this go. It would be legally challenged every single minute. But shit like the Fearless Fund happens all the time. It's a grant program for black women. And they're like, well, yes, get these queens into positions of money making. How many nails and braiding shops can you open? I'm not sure. That was racist. Huh. Okay, anyway. It's true, though. It's true. Or ridiculous clothing. I mean, ridiculous clothing. Have you ever walked by those businesses where you're like, I'm not sure I can go in there, but I'm going to try. And then you go in and everyone looks at you like this. Like you're going to steal something. Like that's not how this works. That's not what happens here. But anyway, there's a bunch of stuff like this. Fearless Fund is like women of color, or it'll invest in like Hispanic students, or it's specific races. And you're like, but what if you did one for white people? And no way, you'd be killed. Actually, maybe killed. A federal appeals court temporarily blocked funding for Fearless Fund's grant program as the case proceeds. Conservative activists have brought lawsuits using the 1981 section against other companies and institutions, including insurance company Progressive and pharmaceutical giant Pfizer. The cases are being monitored. Oh my God, he's scary. Cases are being monitored carefully as the battle over racial considerations shift to the workplace following the Supreme Court's June ruling ending affirmative action in college admissions. And this is the next step, right? They go after the college admissions programs and win, which was great. Really, the idea of DEI in college admissions is offensive, and it should bother everyone that any student of any demographic would be artificially limited by their race. And I thought that we all agreed on that back in the 60s. We're like, maybe we shouldn't do the race thing. Like maybe we should just look at like scores and numbers and stuff like that, and experience that would help out. And like, let's get rid of that whole race and national origin thing. Let's do that. And let's just qualify candidates. And then they're like, well, no, actually we're doing the race thing, but in the opposite way. And so now you have particularly white children and Asian children who are disadvantaged because of their race. And the reality is, and I believe it's in one of the Supreme Court rulings, or at least it was in one of the briefings, if any part of the decision making process in admissions is based on race, then the admissions is based on race. Because the idea is that you could tie theoretically on everything else, and then the only decision making object left is race, which neither party had any control over. And that is an immutable characteristic that we've been told for decades can never matter in achievement. And yet they've made it the most important consideration in college admissions until recently. And it's so critical for them to choose based on race that they're still trying to, even after the Supreme Court said, don't do this, they're still trying to find ways to figure out race and use it. Like, that's how much they love racially segregating people. And it's weird, but I don't know. I don't understand it personally because I like everybody. I'm such a softie. So now, though, they're moving to the workplace, and this is good, right? Because, sorry to go back to me being huge. This is a good thing because ultimately you have this concept where if you're a younger white guy entering the workforce in 2023, 2024 now, you've got to be depressed about your chances. And if you're not trying to make your own way, like if you're not like, I'm going to be Logan Paul, if you're not doing that, I'm at least on the side, I'm not sure what you're planning for your life. I don't know. All my kids, when they talk about what they want to do, it's all independent. They have the right idea. I don't know that they'll end up there, but it's all independent stuff. And so I try and help them develop skills and hobbies that will help them build something independent of someone else and hope that they make that, because I don't know how they're going to fare in a workplace with the way demographic focus is going. I felt this back in 2006 when I worked for Wells Fargo, and then when I worked for Thrivent starting in 2007, and every single manager, every single one, was a woman, and many of them were minorities. And Wells Fargo effectively said that they have a focus on promoting minority and female candidates into management. I was like, well, okay, so why should I work hard? Like, what am I going to try and do? How am I supposed to advance? And I was always told, well, you can look at lateral shift opportunities. I was like, well, that sounds fun. Cool. Fuck you guys. Anyway, this is critical to attack these racial considerations in the workplace. I would add gender considerations, but we'll start with race. While the 1981 statute, now they say 1981 statute, that's the section, not the year. I made a joke about the year because it's my birth year, but that's the section 1981, had been used well before the latest affirmative action ruling to prove reverse discrimination. Alfonso David, Fearless Fund's legal counsel, who serves as president and CEO of the Global Black Economic Forum, said there's a coordinated use of section 1981 now that we did not see before. Like, what a weird way to say that. Here's what's happening, what the impact could be. What is Section 1981? The 1866 Civil Rights Act is a federal law prohibiting discrimination on the basis of race, color, and ethnicity when making and enforcing contracts. Section 1981 specifically grants all individuals within the U.S. jurisdiction the same rights and benefits as, quote, enjoyed by white citizens, end quote, regarding contractual relationships. So that's the actual language. So everybody has to have the same rights and benefits that are enjoyed by white citizens, which is funny how they're using that to like go after the exclusion of whites. But if you think about it logically, if everybody has to have the same benefits that are enjoyed by white citizens, but white citizens aren't enjoying them, well, then I guess you either have to go back or you have to bring whites back forward, right? Like, that makes sense there. But it is funny that is the specific language enjoyed by white citizens is being used now as a bludgeon against the they call it reverse discrimination, but it's not. It's just regular discrimination just against white people. Reverse discrimination would imply that only whites can discriminate, and then reversing it would be bringing it back on them. But that's not true. It's just discrimination. Anyway, however, the Supreme Court's 1976 McDonald versus Santa Fe Trail Transportation decision broadened those protections. Under ruling section 1981 prohibits racial discrimination in private employment against white people as well as people of color. And this shouldn't surprise anyone if you just go back and listen to what I said 25 seconds ago. If it's the same as what's being enjoyed by white people and white people are enjoying something less, then it's got to be the same, which would be less. It's a very clever game plan, said Randolph McLaughlin, a civil rights attorney and law professor at Pace University, referring to the use of the 1866 law. They want to turn civil rights law upside down. No. See, it's the framing up here that matters. And those people are framing it in their assholes. It's not turning it upside down. If the goal is to utilize law to bring people to parity or equality, then utilizing law to bring whites to parity or equality based on the real application that white people are now being discriminated against detrimentally, then that's not turning it upside down. That's using it exactly as intended. And it's so funny that this is everything in civil rights. They say civil rights lawyer. There's no such thing as a civil rights lawyer that's pro-white. Like, there isn't one. If you're a civil rights attorney, you're entirely for the premise that you're trying to right the wrongs of slavery and the ongoing history of racism in the United States. That's what a civil rights attorney means. It's a code word for it, right? But it's all premised on the fact that whites have institutional executive power that must be checked and kneecapped, and everybody else needs to be brought up. And so everything is framed this way. It's like they want to turn it upside down. It's like, no. If you go from the blank slate of everyone should be equal, then it doesn't matter where your focus is, because it's just these people aren't being treated equally, so we want to make sure they are. That's how it works. And then that's not upside down. That's actually correct. That is the correct interpretation of how civil rights law is supposed to play out. But that's not how they see it, because they are inherently racist. The standard of proof in the 1981 section is high. Now, this is the caveat, the difference between it and Title VII. That's because of the Supreme Court's 2020 decision in Comcast versus the National Association of African American Owned Media establishing National Association of African American Owned Media. That was probably written by a mumble rapper. Establishing that the plaintiff who sues for racial discrimination under the section bears the burden of showing that race was the central cause in denying a contract opportunity as opposed to merely a motivating factor. Well, thank God. If you're going after DEI contracts, you know it's the central cause, because they're so fucking happy to tell you how great it is that they're hiring La Blacks, La Mexicans, whatever it is. Like, they just have to tell you. They're like, oh, we're going to definitely import more retarded people. It's like, okay. Like, sorry, that had nothing to do with the races mentioned. I was mixing the FAA thing. Yeah. But they're so happy to tell you, like, we're targeting this race, this gender, this minority, this demographic. We're targeting these people. This is what we want. So it's like, okay, cool. Thanks for telling us. Now get fucked by the law, politely, gently, with a barbed one. But yeah, the motivating factor would be the civil rights, sort of, under the Civil Rights Act. It's much more complicated than that, but we're not going to get into it because I don't want you guys to hang yourselves. Why not rely on Title VII instead? Title VII of the 1964 Civil Rights Act protects employees and job applicants from employment discrimination based on race, color, religion, sex, and national origin. And there's a very important caveat to this. Really, there is. And it's called unless you're white and male. Because the way that Title VII of the Civil Rights Act has traditionally and usually been applied, it does rely on this sort of concept of, how do I put this? Institutional power. It's not institutional. You know what I mean? The idea that white people have this inherent power and so that they can't be discriminated against as easily. So even though Title VII theoretically has a lower bar and it does ban the discrimination based on race, showing an impact specifically against white people becomes very, very difficult under there because of the inherent power of white people. So that's why you don't want to use this instead of the other laws, because you end up with the higher standard kind of by default, just how the law works out. So systemic privilege. That's a good way to put it. Thank you, Rumble. But yeah, that's how it ends up working out. You still have the heightened standard if you're using it for white people in under the 1964 Civil Rights Act. So this is effectively a great way to go about it, because you're not going to challenge on the basis of race in regards to white people unless it's 100% clear. You're not going to win that Civil Rights Act case anyway. So you might as well just go for the higher standard. And there's other reasons that are coming up. But first, I want to read a couple of the chats that have come in because I've been ignoring them. Chandler Halderson's Barbecue and Ice says, you need to look at Oklahoma House Bill 3084. Also, what are your thoughts on First Amendment auditors? First Amendment auditors, how do I word this? They're fucking annoying. They're like the sovereign citizen thing. It's like, okay, yeah, we got it. You read a book, cool. Leave people alone. But they annoy me. I mean, they have their purpose, but they are fucking annoying. VSync says Biden Department of Labor pushing final rule to bring California AB 5 nationwide, destroying freelancers. Check Bridget Fatesey's Twitter feed. Need to rein in executive agencies and leave drastic changes to Congress. I agree. Look. Who needs freelance stuff? Everything should be aggregated into Democrat-friendly corporations. VSync says I'll be discussing the Coinbase versus SEC court hearing on my Rumble feed soon, with an eye on both the market impact and amateurly for implications on Chevron deference, etc. Judge sounded promising. Yeah, Chevron is probably about to get completely redone. I'll be doing a show about that soon. Maybe analyzing some of the oral, see if it was any good, and then talking about what's going on. But a lot of the conservative justices are poised to take a knife to Chevron like a Puerto Rican in an alley. Johnny Duck 311 says you feel weird due to your like Hercules when you cut your hair off. That was Samson. Oh my God, you lose strength. You're just a little weaker today, but fresh. Javier Milius Davos. It was Samson. Didn't you listen to the Jeff Buckley song about it? No One to You says, I actually know a guy who showed me the letter he got from MIT that explained how he met all the requirements, but they weren't accepting white students at the time. Crazy to actually see it. Damn. And Inset Hurdle 88 says, a judge blocked JetBlue and Spirit from merging for risk of monopoly. How can they do this? JetBlue and Spirit? What monopoly? Look, all the shitty flights that aren't going to make it on time, you guys got all those. We can't have that. Look at all the real monopolies we have today. Plus, both companies are $5 stocks and suck. So where's the risk? I mean, I guess they're worried that if they both failed together. Is that like holding your wife's hand and walking into the ocean and never coming back? Is that like what JetBlue and Spirit? Except JetBlue and Spirit might fly a plane into the ocean on accident. God, I don't trust them. I feel like if you flew on JetBlue or Spirit from Minnesota to Vegas, you would die in the Indian Ocean. Like I have a feeling like that's what would happen. I won't do it. I will not fly on either of those airlines. It's like going to a restaurant where the servers like walk on their hands like they're all gymnasts. Like, no, I just don't need that. Why would you do this? Anyway, I don't know. Maybe I'm weird. I'll pay the $8 more to fly Delta. So here we go. If the plaintiff opts to sue via Title VII, then he or she needs to file a charge with the Equal Employment Opportunity Commission. By the way, this needs to go away. The EEOC is garbage, and having to file a charge with them before you file a lawsuit is an onerous burden that prevents people from having immediate access to the court system. And access to the court system is a fundamental right. That's why vexatious litigants are so hard to label. And it's why vexatious litigation is a thing in the first place, because no matter how stupid you are and how many shit lawsuits you file, you have access to the legal system as a right until you lose it. The Equal Employment Opportunity Commission it's a barrier to that right that is, again, unduly burdensome and onerous. If you don't have any money, and all the money that you have is going to sue the people who prevented you from earning more money, having to file with the EEOC. And then here we go. That's a process that takes up to 180 days. So first you got to file with them. Then you got to wait 6 fucking months for these guys to not rule on your thing and to say, okay, well, you can sue now. Then you can file your lawsuit. This costs a ton of money that doesn't need to happen. Choosing the 1981 route is much quicker. Section 1981 is also broader than Title VII. So Title VII is like my shoulders, which generally applies to employers who have 15 or more employees. Legal experts said also under Title VII, a plaintiff can recoup only up to $300,000 in compensatory and punitive damages total. Section 1981 has no limitation. So again, you're talking about getting into these places where if you're discriminated, $300,000 in compensatory and punitive damages is not that much, especially when you figure out a total compensation package for a middle-class job. Something that's going to pay $60,000 to $70,000 a year. The total compensation package on that is probably closer to $120,000 to $130,000 when you figure in insurance, retirement benefits, and other sort of intangibles that go into it. Total compensation packages, this is barely going to be a couple years of that. Plus, you're going to have to give a third-year lawyer. Title VII does have a lower standard of proof than 1981. Plaintiffs only have to show race as a motivating factor, not a central cause. And this is really a bastardization of the standard of disparate impact versus disparate treatment versus disparate impact. It gets really muddy. We're not going to go into it, but this is an okay summary of it. I don't know who this weirdo is. Is this Alfonso? That is Alfonso. He's the Fearless Fund's legal counsel. I don't know. This is why I don't like shaved heads. Like the upper part of his head here, like I'm not a phrenologist, but that's way bigger than the lower part of his head. That's like, I feel like his brain is trying to get out. Maybe he's really smart, but I don't know if that means it's like his head was going to be small and then his brain was normal sized, or if his head was going to be normal sized, his brain's huge. I'm not sure. Maybe someone just pumped saline in. Why is the case against Fearless Fund potentially significant? In its lawsuit, American Alliance for Equal Rights seeks relief by arguing that the fund's Fearless Strivers Grant contest, which awards $20,000 to Black women who run businesses, violates Section 1981 by excluding some people from the program because of their race. Some? Well, some people are excluded. No, almost everybody. It's like they don't exclude some people from the program. They include a very small amount of people in the program. God, the way that, I hate the media. Attorneys for the Fearless Fund have argued in court filings that the grants are donations, not contracts, and are protected by the First Amendment. Now, that's a good one, right? Like, that's a good argument. It's not necessarily a contract, except it depends. It depends on how the grants are actually divvied out. If the grants are divvied out because you fill out an application that has a list of requirements, you meet the requirements, and then you get the grant, that's actually closer to a contract than it is to a donation, because they're not making this donation to just somebody. The donation is predicated on a set of conditions. Once you predicate a donation on a set of conditions, you're saying, I promise to give you this as long as you promise this, this, and this. Well, that's a contract, no matter what you label it, right? Like, I could say that super chats are all donations, but the idea of a super chat is there's a set of promises attached. Not really from me, more from YouTube. Like, I try to read them all, but that's not actually an enforceable promise. For YouTube, though, like, they promise that if you make a super chat of $5, it will display in a little green bubble in the live chat. Your chat will be highlighted. It'll display in a green bubble for the live chat and remain there for 5 minutes. And I think it's $1 a minute as it goes up. So, like, that's part of the promise, and that's where it ends. And then people can do what they want with them. But that is a promise, and it is a contractual arrangement. It is not a donation. It's income for us. It's predicated on the performance of that thing by YouTube. So it's in the same way. I mean, these are mini contracts. Like, you have to be a Black woman who runs a business. Who knows what the other considerations are? I don't really care to find out because I'm not braiding anything. So I'm never going to know what the other requirements are, but it doesn't matter. If there are requirements for the grant, they're not making a donation randomly to a business. They're not going to pull up Mercado Law and be like, that's a black-owned business. Here we go. Here's 20 grand to him. They won't do that because I would have to represent these certain promises to them, and they would have to then decide to agree to them and then promise and then effectively do give me the money. That would be the thing. And if you really wanted to get into it, if they promise to give someone the money based on their meeting the requirements, and then that person acted and said, oh, I'm going to get 20 grand because this letter says I'm going to get it. And then they buy 20 grand worth of equipment. And then the fund bitched out on it. They might actually have a claim for that under something called promissory estoppel, where they're like, you promised this thing to me, and then I acted in reliance on your promise, and then you didn't do it. That's a contract because you knew I would act in detrimental reliance on your thing. So you made a promise based on these representations, and now you're not doing it. So this very much can be argued to be a contract. It is a good argument that it is a donation. And the First Amendment protection, like, no one's saying that it's ultimately illegal. Oh, just a second, guys. God damn, hold on. All right. Sorry about that. They are protected by the First Amendment. No one is saying that these donations are necessarily illegal in concept, just that, you may have a First Amendment right to say you want to make these donations and support these businesses, but your First Amendment, I don't have a First Amendment to fire you and say I'm firing you because you're black, right? That's a bitch, isn't it? David, the Fearless Fund's legal counsel, says that if these types of grants are considered contracts, one can make the argument that grants issued in many other forms and contexts could also be considered contracts. Yes. Very good, David. Yeah, if your grants are contracts, then yes, other grants could be considered contracts. That's really smart synopsis you have there, my friend. Think of every foundation out there that issues grants, David said. They issue grants to people of different demographic groups. They issue grants only to women. They issue grants to survivors of earthquakes. Are those all contracts? Maybe, actually. But survivors of earthquakes isn't a prohibited demographic. You can do that one. Only to women? Well, now you have to determine if that's a valid exclusion of 50% of the population. Only to white people? Would you be okay with that one? Maybe he is. Maybe he's consistent. Maybe he's like, no, it's just fine if you only give grants to white people.
I doubt it.
Yeah, me too. Angela Reddock, right? Jesus. An employment and Title IX attorney and mediator, kill me, based in Los Angeles, believes it's very possible that the case could end up at the Supreme Court. Quote, ideally, the court would decline to hear this matter on the grounds that Section 1981 was not intended to cover matters such as this. Why do you say that? But this court appears to operate under different rules and standards, she said. This is so fun. This court appears to operate under different rules and standards. No, they don't. Stop this. Silliness. What impact have similar lawsuits had? Some companies have already changed their criteria for their diversity fellowship programs. This is good, in my opinion. Do you guys remember way back when you were in we're talking for me. I'm talking to the guidance counselor back in the fucking Stone Age of the 1999 and 2000. And they're talking about college. And it's like, well, you could apply for this. Oh, wait, no, you're not Latino origin. What about, no, you're not any minority. Okay. And they're going through these grants. And I'm like, well, like, are there any for me? And they're like, well, no, you're a bad student. And I'm like, but not that bad. Right. But they're like, the only ones for bad students are for minorities, which I thought was rude that she said that, but she did. And so this has been around forever. Like this idea of giving grants based on race specifically and fellowships. Like that's been there. And every person who has come up across these who can't qualify goes, well, how is that okay? Like if I did this, I feel like I'd be in trouble. And you would. Yo Pops 215 says Ricada equals the blackest owned business. Preach. Wait, Cyberhunk 2069 says you can tell the character of a man by how much he's willing to compromise his own biases for the sake of objectivity. You have character, Nick. Oh, thank you. I try. I try. Law firms Morrison Forrester and Perkins Coie, the enemy, opened their diversity fellowship program to all applicants of all races in October. I'm so proud. So proud. See, the funny thing is, when you read that headline, like, oh, they opened their program to all races, you think of like Augusta National Golf Course, where they're like, finally, Tiger Woods has broken the race barrier and they'll let the blacks join instead of being a guest as they're winning the Masters. But no, it means they open them up to white people and Asians. Changes the company said were in the works before Blum filed lawsuits against it. Did you notice, though? I have to say it. It's not even right, but it's not even, it's correct, but it's not okay that I have to say it. Do you notice how, despite their prominence in like all of these professions and places, Jews are never excluded from fellowship programs? It's like, we got too many whites and Asians. So it's like 80% Jewish. Like, that's fine. Anyway. Perkins and Coie. Changes the company said were in the works before Blum filed lawsuits against him. He subsequently dropped them. See, he won. Actually, that's funny. This Howard Blum guy, he beat two of the biggest law firms in the country just by filing these lawsuits. Because while these other people are like, well, this isn't fair, they're like, we're fucked. They knew how bad this is going to be. So they just changed them straight out. Previously, the programs for first-year law students had targeted students in historically underrepresented groups. Historically underrepresented groups, which is code, again, for typically Black and Hispanic students. Morrison Forrester's fellowship program now caters to students with demonstrated commitments to equity and diversity. Oh, God. Ugh. Look, you're talking to lawyers. Just lie to them. Perkins Coie announced that it had opened its fellowship programs to all applicants, regardless of their race, gender, or LGBTQ identity. Again, so thank you so much for that. In a statement, Perkins Coie said the changes arose as part of updates to its diversity and inclusion policies following the Supreme Court's ruling on affirmative action. Yeah, and this has all of these people so fucking scared. And it's funny because the guy who wrote the words affirmative action back when it first came about actually spoke to one of my classes in law school. And he sat there and told us for like an hour and a half emphatically that what he wrote down when he said we need to take an affirmative action has nothing to do with we need affirmative action, which is what it's been bastardized into. He said he was not talking about affirmative action as we understand it. He was talking about the literal opposite of affirmative action. He was talking about taking an affirmative action to be colorblind in hiring policies, in grant policies, in all of this stuff. Affirmative action was supposed to mean the opposite of what it is. They took off the an affirmative action to ignore race and made it into affirmative action to focus on race and fix the problems. His theory, his entire thesis behind that affirmative action that we needed to take was that if we just colorblind ourselves and if we just gender blind ourselves, we'll actually reach demographic parity really quickly because people will just work out through the statistics. As long as we're not looking for race, as long as we're not looking for gender, we won't find either. We'll just find qualification. Oh my God. Was he completely distorted? Really interesting cat, though. I'm talking like Drexel. Last February, Pfizer dropped race-based eligibility requirements for a fellowship program designed for college students of Black, Latino, and Native American descent. A judge had dismissed a lawsuit filed by the conservative nonprofit Do No Harm, which claimed Pfizer's program violated Section 1981, but Do No Harm is appealing the ruling. Wait a minute. Oh, because they had dismissed it. But anyway, they dropped their eligibility program. So that's interesting. So since they dropped it, they're appealing the ruling. I guess they're going to allege past damages. What would work in companies' favor is to lower their profile, said University of Virginia's distinguished professor of law, George Rutherglen, which means they do not explicitly consider race in making these decisions. Look to other conditions and requirements that might achieve the same objective. And this is the thing. The funny thing is, this is always kind of the way people suggested this should be done, is like, if you don't just say you're going to hire black people. Like, you can do whatever you want. Just don't actually say it, right? Just get their address. Don't do that. That's mean. How do I work this? This is what they're doing in college admissions right now. And this is the funny thing. They've encouraged this. They're like, well, look, don't say you're black because we can't decide based on that. Just talk about how you don't have a dad or whatever. It's like, oh my God, that's horrible. But that's they're telling them to do. They're like, write about your life experience in a way that will indicate to us what race you are. So if you're like Eminem, you're like, well, look, I lived in poverty and I don't have a dad. My mom's insane. She beats me. It's like, oh, this guy must be black. And then he shows up and they're like, Jesus, what happened to you? He's, sorry, I walked through a bleach machine. Thanks, Marshall Mathers. Anyway, this is just fun because this guy, Howard Blum, who looks like, God, he looks like a villain in a Pixar movie, doesn't he? It's like, how many evil corporations does this guy own? All of them at once. They're just going to trash every planet. But this guy's like, I have an idea. I remember when this law was written. It was written to stop them or stop me from my good contracts. And now he's going after him. He's like, ha, revenge is mine. He's been waiting since 1866 when he looked the same to bring this legislation. And now he's bringing the fucking hammer down with this old law, all centered around race. And I can't stop being amused by it because I'm like, you guys wanted the fight on race. You just wanted it all the time. And like, if your narrative is correct, white people are good at winning the race war. Like, you keep talking about how successful they've been throughout history. And they're like, but now we want to fight the race war again. It's like, why do you want to do this? If white people are good at it, this is a bad strategy. You should go about it a different way. But no, they keep going after it. And I don't get it. And then some old white guy comes out and is like, yeah, I read the law once. He hires a bunch of lawyers who are like, this will be funny. We got to do this. Plus, this guy has money. So even if he loses, we win. And they're good with it. They're good with it. But God, it's great. It makes me happy that they're going after this. Insert Hurdle 88 says, went back to college. Got in a heated debate with a class on why the amendment is still, the Equal Rights Amendment is stupid. The 14th covers it with Title 7, 9, etc., but they said it wasn't good enough. Have you read the ERA proposal? The ERA amendment? No, what is this? ERA amendment proposal? Is this the woman one? Oh yeah, the woman one was super stupid. It's also like they can't bring it back. They would have to redo it. They missed it. They wrote the time window in there, and if you write the time window on an amendment, you don't get to like violate the time window. That's why they wrote it there. I don't know why people mix that up, but well, they probably didn't mean the time window. No, they did. That's why they. All right, what's next? Oh, this is the. Speaking of racism, we're going to talk about. Oh fuck! I have this. I thought I had this pulled up. Damn it! I don't. Hold on. Luckily, I archived this earlier. When I did this earlier, I just must have undid it. Hey, that's mine. Here we go. So speaking of racism, this is another one of those things where it's accidentally super racist. So federal judge says the DOJ presented no evidence that black Georgia voters would be hurt by shorter early voting. So there's just walk with me for a second. Don't run because I'm white. I'm not very fast. Walk with me for a second. They pass a law in Georgia and they're like, you know what? These time limits are way too long for early voting. People don't need to vote this early. So we're going to just shrink these out. And the Department of Justice under Biden's like, wait, if you shorten the early voting thing, if you make it, black people won't be able to figure it out. And you're just like, I didn't know they knew how to be early, is the first thing you think. And then the second thing you think is, wow, these guys legitimately believe that black people cannot use calendars. Like, we know that black people cannot navigate getting a driver's license. We've learned that. or like any sort of identification, because it's racist to require that. It's like, well, how could they get an ID card? It's like, I don't know. The same way everybody else does. The same way black people do. When is this a problem? They're like, no, they can't possibly get you can't expect them to get a government ID card to go vote. It's like, who do you even know? But now they're like, they can't use calendars. You can't shorten this to just 29 days early. Like, you have to understand, it's 29 days early. It's a whole fucking month early of vote. Well, just a February. And they picked 29. It's a leap year Black month. Okay, whoever picked 29 days, if they did not pick it because it was first historically Black month because it's February, but also a leap year because they jump high, then I'm mad at you if you didn't do that on purpose. I'm mad at you. But it's 29 days before voting. Like, oh, God, it's just... Anyway, here we go. Plaintiffs alleged the plaintiffs being the Department of Justice, the law unfairly targeted Black voters, but the federal judge said no evidence supporting the claim was presented. A federal judge in Georgia will not strike down an election law tightening registration dates and mail-in votings for runoff elections. At the heart of the case was an election law, the Election Integrity Act, championed by state Republicans, that seeks to shorten the time frame for Georgia runoff elections from 9 weeks to 4 weeks and reduce the window for mail-in ballots. When no candidate wins a majority in Georgia elections, the state transitions to a runoff. This unique system has forced elections to be dragged out for weeks, well after the rest of the nation's results are confirmed. All right. Democratic opponents, joined by the U.S. Department of Justice, tried to claim the stricter voting period unfairly discriminates against Black voters. How? How is this discriminatory? I mean, I know I'm just a
white bread ass niggas, man,
but I just don't get how it discriminates in any way. Preventing individuals from registering to vote between the first election and a hypothetical runoff. U.S. District Judge J.P. Booley ruled Friday that plaintiffs did not offer any evidence supporting their claim that Black voters are uniquely impacted by the law. Quote, plaintiffs presented evidence that Black voters are more likely to vote early. See, this is cool. So plaintiffs present evidence that Black voters are more likely to vote early. That's great. That doesn't help their case, I don't think. They did not present any evidence, however, which would show why Black voters would disproportionately struggle to vote during the new early voting period. So they're more likely to vote early, but it's got to be real early, I guess. State Republicans applauded the court's ruling in defense of the law, which they believe will protect the integrity of the voting process. This ruling affirms what we've maintained all along. Georgia's Election Integrity Act is designed to ensure fair and secure elections for all citizens. Georgia Secretary of State Brad Raffensperger said in a statement. This guy, like, good. Brad, get fucked. Oh, that's the end of it. Oh, wait, no. He added, what's that? Why didn't you just put that above? He added, we will continue to stand firm in defending the principles of this legislation. Brad Raffensperger can stand firm on my dick. That guy sucks. But this is a very sensible law. The problem is you've got this. You can have a general election, come up with a tie like we had in the not a tie, but close enough that you have to have a runoff. We didn't have it with the presidency, right? We had it with the senators. And then the problem was because of the early voting window, you could have people register between those two votes, which means you could change the voting populace for the runoff. That's weird. And they're like, this will affect Black people. It's like, that doesn't make sense, though. And there's no explanation in this article as to how that would somehow affect Black people. They didn't present any evidence of it, says the judge. I'll take his word for it, but I'm still not sure how it would in general affect anyone. They're just saying Black people are more likely to vote early than other demographics, but that doesn't mean that then shortening the early window means that Black people are less likely to be able to vote. But it always comes down to this. It's called the soft bigotry of low expectations, right? Black people can't do this. Black people can't possibly get an ID card. Black people can't possibly, oh God, I mean, the shit that we could get into that they're trying to like protect Black people from themselves on is just insane. Especially some of the workplace stuff or like the, hairstyle requirements and stuff like that. It's like, well, you can't expect them to change their hair for work. It's like, well, wait, I mean, everybody else has to. Like, why? It's like, well, it targets ethnic hair. It's like, no, it just targets hair. Like just hair. Because white people can have dreads too, or cornrows. I mean, have you ever seen wait, who's the white guy who had the cornrows? Every white female basketball player. But no, it's this shit happens all the time. And they always do this. It's such an apologetic for African Americans, and it's always the most offensive way possible. It's like, well, they can't be expected to do that basic thing. It's like, why not? Oh my God, like all the black people I know have no problems navigating this stuff. Who do you hang out with? Well, if it's a politician, the answer is probably minors. With an O, not an E. God, I hate politicians. Yo Pops 215 says reverse CPT, reverse colored people time. Like they're always 22 minutes early every single time. Did I ever tell you guys when I learned that black people time was real? I was with Drexel. We used to go. There was like a summer where we hung out every single day. We were trying to beat Battletoads 2-player. So that was like a big part of our, like daily routine. We would watch, no, we wouldn't watch show. We would play Battletoads until the Nintendo gave out. Like you had like an hour and a half on an old Nintendo and that would give out. And then we would get food and then we'd go back and to either his house or my house and we'd play a different video game or play Battletoads again, or we'd go watch like a movie at the movie theater. And then it'd come to around 11 o'clock, midnight. We'd go to Perkins. There's a Perkins in Lakeville, and we would go there, and we'd stay there till 5 a.m, 3 to 5 a.m, every day, every single day. And it was cool because we would go there enough that most of the food and stuff we ordered was just free. So we would just sit there and drink like vanilla shakes because he's racist, and we would eat pie. We could eat pie for free. We'd have shakes for free. We could have ice cream for free. But if you bought like a meal, like you had to pay for the meal. You could get free muffins. We could get free muffins. So one day we're going to meet his brother there. And we show up and we're sitting there. I'm like, where is your brother? This is retarded. I want to order food. He's like, look, he's on black people time. What's that mean? He's like 22 minutes. On the fucking dot. On the dot. 22 minutes. He shows up, sits down. Hey guys, what's up? I looked at Drex. I was like, I fucking hate you. I hate you for this. He's like, 22 minutes, black people time. And then we went and saw Undercover Brother, right? Do you remember they have all the clocks? If you've seen Undercover Brother, they have all the clocks on the wall, like Chicago time, New York time, LA time. Then they have colored people time. It's 22 minutes later. It's like, come on. It's real. It's a real thing. Sorry, that's my rant about colored people time. Dallas guy 98 says, fuck DEI. The NOAA, National Oceanic whatever Association, gave a presentation on how they only wanted to fund people of color, how their lawyers said they can't, and how they got around the law. This happened at the Geological Society of America. Yeah, it doesn't surprise me at all. They'll always find a way around it to discriminate in favor of DEI. Like that will always happen. That's why I'm so surprised they keep trying to do it out in the open. Just do it surreptitiously, like you accuse white people of doing. Like all the tactics. You blame white people for it all the time. Just do it that way. No one cares at the end of the day. But if you come out and say it, then everybody knows. Most people are not applying for a fellowship at Perkins Coie. They don't give a shit if you give a fellowship to black people at Perkins Coie. Just don't scream into everybody's faces, we're giving fellowships to black people. Don't do that. We don't care. Jesus. Okay. Sorry, I got to calm down. Ben SC says, actually, JetBlue and Spirit are safer these days. Look at this. Look at this discount apologist over here. They buy most of their planes used. Thus, no 737 Maxes with the doors flying off. It was one time. Those have already crashed with their first owner. Well, maybe it was the owner's fault. Have you ever thought about that? But wait, no, that's specious reasoning. I'm going to call you out. You say, well, look, Spirit and JetBlue haven't had the doors fall off of their planes, but then you said they don't have that plane. See, If Spirit and JetBlue were flying that plane, the door wouldn't have fallen off. The plane would have crumpled up like a Pringles can under the ocean. I don't trust it. And I'm not talking about planes falling apart. I'm talking about planes disappearing. Dallas guy also says, if you need fence staining in Dallas, I'm supposed to use bigger voice. If you need fence staining in Dallas, RobinsonFenceStain.com. Fuck Wickard versus Filburn. Fuck Chevron deference. That a boy. Yo Pops 215 says, shit, I can use some goddamn fellowship too. We all could use some fellowship. Everybody get together and have donuts. Everybody get together and have donuts. Michael W. said 22 minutes later is black people time. Does that have something to do with the catch-22? I don't know why they made it that way. I don't know why black people got together and decided that was the time. It's just it's just what they did. Okay, what's this last one I have? Oh, this is Trump in court. We've got Trump in court. I always love these because they don't allow cameras in these federal courtrooms. So you get these shitty sketches. Like, this is the worst Donald Trump sketch I can possibly imagine. Like, they could have, I want them to do the funny ones and they just don't. But hey, here we are. Did you say fuck donuts? What's wrong with you? What is wrong with you? Fuck donuts. Oh my God. I should ban you from chat for that. Dark Loose G says, just finished uncivil / Pisco discussion. So much bad faith / word salad and illogical arguments from Pisco. Yes, you just described him. Now I no longer care to speak to anyone on the left in any capacity, national divorce or purge. I don't care. No, don't blame all of the left for Pisco. He's his own special beast. Sleeping Psycho. I worked with a black lady who thought 9 o'clock meant she wasn't late as long as she showed up during the 9 o'clock hour. 9:59 was on time. That's how I do it. I don't blame her for that. Okay, a federal judge threatened to kick Donald Trump out of court Wednesday after the former president made repeated comments within earshot of the jury hearing a civil defamation trial against him. Attaboy, Donnie. Attaboy. You know what is funny about this? This case shouldn't even be here right now because Donald Trump he's asserted presidential civil immunity. This is the case. This is the second E. Jean Carroll defamation case over statements made while Donald Trump was president. The other defamation case was made over statements he made while he was a candidate. So they're two separate issues in two different courts. This is in federal court, and E. Jean Carroll is suing him over these. He has asserted presidential immunity from civil suit. However, the judges said that he cannot assert that authority because his executive immunity because he waived it, which I talked about this the other day. The entire premise of civil immunity for the president is based on the idea that the judiciary doesn't have jurisdiction over the president because that would be a violation of the separation of powers. So if the judiciary can't actually assert authority over the president without violating the separation of powers, it shouldn't be even possible to waive that, but they've ruled that he waived it. So this is one that may go to the Supreme Court. But in the meanwhile, the case continues. Now, Trump is already pissed at this judge because he tried to get this trial to start a week later because his mother-in-law's funeral, Melania's mother, passed away recently. His mother-in-law's funeral is happening, I believe, on the 25th of this month, and he wanted to attend it. And the judge said, no, I'm not going to delay the trial. You don't have to come to the trial. You can go attend the funeral, or you can attend the trial and the funeral, or neither, whatever you want to do. You don't have to be here. But that's kind of shitty, in my opinion, because you have to choose then to not show up in court. And there are implications for not showing up in court, not legal ones, but there are perception implications, and you miss stuff. You have to sit there and rely on the representation of what happened in court from someone else rather than being there for it. If Trump wanted to be there that day, he either has to shun going to his mother-in-law's funeral, which might put some friction with the missus, which I hear endless news stories about, or he has to miss the trial. And if he misses the trial, what does he miss? Can't get it back. Can't sit there and make comments. So he's already pissed at this judge. So the judge is bitching at him for being Trump and sitting there going, bullshit. It's terrible. Nope. Completely false. Wrong. He's just sitting there saying comments you can imagine, like these innocuous statements. but it's got to piss off this judge. Trump muttered that the case is a witch hunt, among other similar comments, according to a lawyer for the writer E. Jean Carroll, who is suing Trump over derogatory comments he made about her while he was president. I'll make some derogatory comments. She's ugly, terrible. I would never think to grab her by the pussy. I'm not even sure if she has one. I bet it's a big honker down there. She'll probably call it a clitoris. It's not. It isn't. That's not. At some point, it goes beyond that. That's a pole vault. The episode prompted a stern rebuke from U.S. District Judge Lewis Kaplan, who repeatedly tussled with Trump and his lawyers during a testy courtroom session Wednesday morning. Quote, Mr. Trump has the right to be present here. That right can be forfeited, and it can be forfeited if he is disruptive, which is what has been reported to me, the judge said. And of course, guys, if Trump isn't kicking for the uprights on this, trying to strategically get kicked out of this court at the exact right moment, then I don't have faith in him anymore. I know that is probably the plan. Trump has used every single lawsuit strategically to generate buzz, generate interest, generate name recognition, as a platform to get a statement or message out for free to the entire world. The media has fallen into every single step of that he has taken. And if he gets thrown out of his own trial because he's just being Donald Trump, that does not hurt Donald Trump for the presidential election. It just goes to show this justice system is bent against him. Whether or not that's true, it is definitely true, because Trump can make that case and people will believe it. And they should. They should, because whether or not it's true, it is actually true. I know that's a weird way to phrase it. But this justice system, whether or not the system itself is bent against Trump, it's being bent against Trump by motivated actors in every sector of the justice system. They're all treating him differently than they treat everybody else, but then pretending that presidents, former presidents, and specifically Donald Trump are equal under the law. They want it both ways. He's showing the hypocrisy. It's brilliant. Kaplan then spoke directly to Trump, who was seated at the defense table. Mr. Trump, I hope I don't have to consider excluding you from the trial, he said. I understand you're probably very eager for me to do that. At that point, Trump threw up his hand saying, I would love it. I would love it. Good. Of course he would. Yeah, throw him out. I dare you, double dog dare you, triple, quadruple dog. You don't even have enough dogs. I've got way more dogs than you. Better dogs, bigger dogs. Dogs that breed better, dogs that run faster. My dogs don't eat babies. Your dogs probably do. You like those pit bulls? And then he says, I know you would. I know you would, Kaplan replied. You just can't control yourself in this circumstance, apparently. Trump shot back. You can't either. Oh. Guys, you know what the best part about Trump is? Everybody like bitches that he acts like a child or like a toddler or whatever. And yet they can't help reducing themselves to his level. They can't help it. This judge's like, you'd probably love that, wouldn't you? I would love it. I know you would. He's so fucking mad. It's like, you just want Trump to be like, are you mad now? Are you angry? I'm not angry. I'm calm. You're mad. I'm not mad. It's just this, and they can't take it. They cannot deal with a man like this. And it's been years and they still can't figure out how to do it. It's like, just act like a normal person instead of acting like a fucking spasm. And they can't. This simple instruction, they can't do it. God, it makes me so happy. His base immaturity makes them I'm getting large for this one all the way. You have to understand this about judges, okay? All judges, it doesn't matter, it takes a couple minutes. They put on that robe and their dick grows 9 inches. And they're like, I'm about to gavel some motherfuckers' lives into whatever I choose. They become so immediately entrenched with authority and power because with the stroke of a pen, they can take away your life, They could take away your property. They could take your children. They could take away your job. They could take away your name. They could take away anything they want with the stroke of a pen. And what can you do other than to complain to another asshole that thinks the same way and beg that guy to undo what this guy did? And the entire time you are paying ungodly amounts of money and they're getting paid for it. They don't care. They are entrenched in authority. They are the most easily attainable egoists on the planet, because once you tell them you have the full force of government behind you, and the worst, especially a federal judge, they're appointed for life. Federal judge came and spoke at our school, and he said when he first became a federal judge, he talked to his mentor, which is another federal judge. He would send him an email every time he screwed up. And the guy just started responding back, is it impeachable? And the list of things that are impeachable for judges is small. Bribery. Not even really being intoxicated on the bench. Literally, it's like bribery or just not showing up ever. And he'd send back, no, it's not impeachable. And he goes, who fucking cares? Who cares? It's not their timeline and it's not their money. They're getting paid no matter what they decide. So for them to go, fuck it, appeal it. That's your money. That's your time. That's your life. And they don't give a shit about it ever. So for these judges who get entrenched in this power and authority that they have, who will sit there and realize that they are in a unique position to determine what reality is for someone else with borderline impunity. If you can bring them down to little bundles of immature rage just by being there going, it's a witch hunt. This is bogus. This isn't real. Just by making these little under your breath comments. And then when a judge says, you'd probably like it if I discipline you for this, you're like, I would, I'd love it. He just responds, and then they lose their fucking minds. That is the funniest thing on earth, because these people are so pointy-headed. They're so erudite and astute and austere and stone-faced, and they will lecture you for days on morality and propriety. And, oh, well, blah, blah, blah. I watched this guy lecture a woman who turned behind a bus, behind a stopped school bus. Mind you, so the school bus stops, and the law is you have to stop 20 feet behind a bus. She took a left turn because the bus is parked in such a way that she could turn left, seeing everything, but she entered within that 20 feet zone of the back of the bus. No danger of running over any kids. And this judge lectured her on morality and safety from his dais with a robe. And I'm like, look, dude, this chick just turned left and didn't know 20 feet based on her eyes. I don't know any women that can measure things by looking. So we all rely on this. That God made it that way on purpose. It's not your fault, ladies. It's ours. But like, she just turned, and this judge is treating it like some moral failure of this person. It's like, she didn't follow a fucking statute for traffic. Like, this isn't a big deal. You will see judges do this over and over and over again. They will issue a ruling, and then they will lecture the person and teach them how they should live their life better. It is the most condescending faggotry that could possibly exist. It happens every day in every courthouse from goddamn near every judge and goddamn near every case. It's just great. I can't wait for mine. The shadow ban says it's starting to bite Jewish people slowly, but it is happening just as with Asian people. Thank you. Let's see. Cyberhunk 2069 says, all I want now is a clip of Trump saying clitoris. Clitoris. I never even thought of. Oh my God. Inset Hurdle 88 says, first presidential debate is at Texas State College, tiny town, San Marcos, Texas. I kind of wanted to go there for a little bit. Just settled a suit with the DNC for the Trump train hitting a bus on I-35 in 2020. $10 says they play that video at the debate. That'd be cool. That'd be great. Trump says, yeah, the clitori. Trump's like, I never refer to clitori in the singular because I've never seen just one. Never seen just one at a time. Always two. You got to be doing bigger and better than everybody else. All right. So here we go. Trump shot back. You can't either. He's mocking this judge now. Kaplan's threat came after Carroll's lawyers complained twice that Trump had muttered during Carroll's testimony in ways they believe the jury. He's muttering. He's muttering over there. Carroll lawyer Sean Crowley told the judge that Trump had said it is a witch hunt and it really is a con job, echoing comments he has previously made about the case. After jurors watched a 2023 video of Trump calling an earlier trial against Carroll a witch hunt and a disgrace, Trump said, "It's true," according to Crowley. Okay. So Kaplan, who has been a federal judge since 1994, this guy has been immune from criticism for 30 years. You just have to understand like what that does to someone. Also oversaw an earlier trial in a case brought by Carroll, who has accused Trump of raping her in a department store dressing room in the 1990s. The jury in that case ordered Trump to pay Carroll $5 million in damages after finding Trump sexually abused and defamed her. Not rape, to be clear. In the new trial, which began this week, Carroll is seeking at least $10 million in damages. Trump never set foot in the courtroom during the first Carroll trial last year, but he attended the first 2 days of the current trial. After a lunch break, one of Trump's lawyers, Michael Medallo, asked Kaplan to recuse himself, saying Kaplan had immediately accepted the assertions of Crowley, who Medallo noted was once a law clerk for Kaplan, and that Kaplan had displayed general hostility toward the defense. Kaplan replied, denied. Hold on, guys. Just a second. We're going to finish up in a minute. I got to go to the bathroom. I'll be right back.
He drank a fair bit and then realized that his bladder can't handle the liquor inside, leaving us with his chair while he runs up the stairs, hoping the stream doesn't suddenly die. While we are waiting, we'll be laughing at you. The drinking along is what most of us do. The chat is united, getting excited. What you have for us when your pain is through. When you have some bladder and no sphincter control, freedom of liquor doesn't mean freedom from soaking your drawers. Now you're washing your hands and you realize that you've forgotten to scrub both the front and the back. Then you'll grab a quick bite, kiss your lady goodnight, and remember to thank her for all of the snacks. Whoa, water will cure your hangover. Oh, so drink some when the stream is over. When you have some bladder and no sphincter control, freedom of liquor doesn't mean freedom from soaking your drawers. Soaking your drawers. He drank a fair bit and then realized that his bladder can't handle the liquor inside, leaving us with his chair while he runs up the stairs, hoping the stream doesn't suddenly die. While we are waiting, we'll be laughing at you. The drinking along is what most of us do. The chat is united, getting excited. What you have for us when your pain is through. When you have some bladder and no sphincter control, freedom of liquor doesn't mean freedom from soaking your drawers. you're washing your hands and you realize that you've forgotten to scrub both the front and the back. Then you'll grab a quick bite, kiss your lady goodnight, and remember to thank her for all of the snacks. Whoa, water will cure your hangover. Oh, so drink some when the stream is over. When you have some bladder and no sphincter control, freedom of liquor doesn't mean freedom from soaking your drawers. Soaking your drawers.
All right. All right. Sorry about that. I was trying to wait, but hey, I'm old. Got an old man bladder. Old man. Back to this stupid story. So he's displayed general hostility towards the defense, which obviously, the majority of these judges, they fucking hate Trump. They hate Trump. They hate Trump's lawyers. They hate the audacity that someone would, actually have to defend Donald Trump or take his case. They're like, no, he's a monster. So we definitely don't want you to do that. How dare you? That probably violates your ethics or whatever. And it's like representing Alex Jones in a way. And we saw what happened to Norm Pattis. He represented Alex Jones. He got his license suspended for 6 months. They don't want people to have access to justice. Trump is a special case in every case. Here we go. Insert Hurdle 88 says, show's over. I'm just typing now. It's $2 minimum. Yo Pops 215 says, damn, Nick, hurry the fuck up. And then he all said, front to back and wash your hands. Thank you for the tips. I didn't know how. Benessie says, it probably looks like a roast beef sandwich and an old leftover roast beef sandwich, a nasty one, a nasty leftover roast beef, not a beautiful Arby's sandwich, more like a Hardee's. If you've been to a Hardee's, Carl's Jr., they have roast beef, but you wouldn't want it. You wouldn't want to eat it. That's what I assume E. Jean Carroll is like. I haven't heard. Nobody's ever seen it. Nobody wants to. Disgusting, horrific, horrifying, really. Did you wash your hands? No, I just licked my hands. Guys, urine is sterile. You could just lick it off of your hands. You don't have to wash it. So weird. Nose, how about if I were only eat water and walk uphill for 3.5 hours daily for a week? What's your opinion on how many pounds would I lose? Wait, so only water and walk uphill for 3.5 hours daily for a week? Okay, so the rough rule is a 3,500 calorie deficit is 1 pound of weight loss. So it really depends on how big you are to start as to how much that would be. But in effect, if you want to lose 1 pound a week, have a 500 calorie deficit. Without knowing how much you weigh, I can't tell you what it would be, but only eating water for, well, drinking, I would assume. Maybe you're just eating ice. I don't know. Only having water for a week is going to be a massive caloric deficit. It's probably unhealthy and you're probably going to feel like trash. But do it anyway. And then do it twice. Eat less than water. When you think about getting hungry and eating water, eat nothing. Eat nothing instead. In fact, stick your finger in your throat and then vomit up whatever's left. If you really want a weight loss program, take out your internal organs. Just give up your kidneys. Why do you even need those? The only one you need to keep is your liver. That's the only organ that matters. Because I know you have no heart. Dallas Guy 98 says, go to Texas State to float. Did you see the Jew tunnel? No. Oh, to go, so go to Texas State, what, to do to float? Is there like a river? You float in like, because like that's near New Braunfels, isn't it? So you could go to like Schlitterbahn, which is cool. But I don't know. So anyway, they asked him to recuse himself. Denied. Trump's agita came as he watched Carroll testify for hours about how Trump's denigrating comments have affected her. After Carroll came forward with her rape allegation in 2019, Trump claimed he had never met her and suggested she was motivated by money. No. Look at that. If that's not a Skeletor face you want to just take to Pound Town, I don't know what is. How is your lower jaw shaped like a banana to your forehead? Like, Jesus, she's horrifying. On the witness stand, Carroll told the jury that Trump's comments ended the world that I had been living in. This is one of those fun things, right? So E. Jean Carroll has claimed that after Trump made comments about her, she started receiving rape and death threats, which I bet there's Sargon rape threats, right? Like, you know, they are. Like, I wouldn't even rape you. Like, you know, that's what the rape threats were. Like, he threatened to rape me. No, it's the opposite, Jen. Jen, it was the opposite. Poor Carl. The most misunderstood man on the planet, Sargon of Akkad. Like, please, I think, soapbox time. I think Sargon of Akkad was wildly defamed. And I'm going to stand up for this man with every inch of myself, which is at least one. And I'm going to say that Sargon of Akkad was defamed whenever anyone said he threatened to rape Jem Phillips. Because he did not. He said, I wouldn't even do that. And then they're like, see, there's a rape threat. That's the most defamatory thing I can think of. Like, as a joke, but also as reality. One, because she's hideous, and two, because it's really terrible to say someone is threatening to rape someone when they didn't. When they expressly said the opposite. I'm going to guess it's a majority of her quote unquote rape threats. I never believed like the death and rape threat thing until people produce it. But I don't actually doubt that she received some really nasty emails. However, what I am going to say is she claims that it took once Donald Trump made comments about her, then she received those threats. But Donald Trump didn't make the comments about E. Jean Carroll out of the blue. He didn't just one day wake up and go like, oh, she's ugly. Like, he didn't do that. He didn't decide to talk about her. She came out and said he raped her. It's like, I didn't do that. That's terrible. She's horrid. She's ugly and hideous. And then they're like, oh my God, once he made these comments, and that fucked her whole life up. Those are defamatory. It's like, wait a minute now. I have a problem with this. Now, of course, there was another article breathlessly reporting about her when she said that, when she answered this way, that once Donald Trump made comments about her, that's when all the threats and horrifying comments came in. They're like, they just completely undermined Donald Trump's defense. It's like, well, I mean, probably just because the court's completely biased against him in this case, but it's not like he did it unprompted. So, well, to have the president of the United States, one of the most powerful persons on earth, calling me a liar for 3 days and saying I'm a liar 26 times. I counted them. It ended the world that I had been living in, she said, and I entered a new world. No, you entered a whole new world when you accused the president of raping you, which he didn't do, by the way. Jury found out he didn't do that. Now, they did come up with the weird claim that he sexually assaulted you without raping you, which is like a very odd conclusion. And I've talked about how legally untenable that conclusion ended up being in the other defamation case, but it is there. But he didn't rape you. So you did lie. You're a liar. But you chose to enter that world. You chose to do it. And I know it might not be fair if you are an actual victim that when you accuse someone, now you've brought it to light, but that is part of the process. Like if you accuse someone, you are bringing it to light. And if you accuse someone famous of something, you're going to receive backlash. Though Carroll said she was once known as a writer, now I'm known as a liar and a fraud and a whack job. Yeah. As a result of Trump's remarks. No, that's not why. Carol's lawyers also asked her about the thousands of insulting and threatening social media comments she received and has continued to receive in the wake of Trump's verbal attacks. Asked about a derogatory messages about her appearance, Carol replied, "It makes it hard for a girl to get up in the morning." Well, you make it hard for a guy to get up at any time. I know I'm old. I know I'm 80. Oh, sweet cheeks. I'll call you ugly at any age. I know I'm not a pretty young woman. You can just take out the young part. It doesn't matter. But it makes it tough to go on with the day, she said. Before the trial began, Kaplan ruled that Trump's comments about Carol while he was president were defamatory. So the only issue for the jury to decide is how much money Trump should pay in damages. Now, this is like this. I think it's only the second case where this has happened, where at the onset, Trump's comments are ruled, or Trump's found to be liable. The only question is, how liable is he? And the answer is going to be, for all of them, the maximum liability. Like that's what's going to happen. But that's how it's going. Like, it's amazing. This keeps happening. It's like, well, in the other case, we determined that you defamed her, so now you defamed her again. Except, I don't think that's true, because she claimed he raped her and he didn't, according to the jury. But hey, Trump has nonetheless continued to attack Carol on social media. Good. Might as well. Calling the case a hoax and hurling numerous other insults and allegations, even as court was in session. On Wednesday, Carol's lawyers even introduced one of Trump's posts from Tuesday into evidence to demonstrate Trump's relentlessness. Trump, again, if someone is lying about you and you're going to say something about it, I hate this idea. It's like, well, you shouldn't say stuff about these people while you're in a case. No, I'm not saying anything about the people. I'm saying that this is all bullshit. It didn't stop being bullshit just because we're in court. He repeatedly denigrated Kaplan on his social media account. Again, good. This fucking Kaplan guy, first of all, he's a big boy. He can take it. Second of all, Kaplan hates Trump. He already does. It's not going to not hate Trump if he's nice to him. It's not going to suddenly give him a fair shake. Dallas Guy 98 says, yes, New Braunfels has a river to float. I'll bring the whistle pig. No glass, so you'll have to trust my whiskey receptacle. Fuck Wickard versus Filburn. Texas suppressors are a state right. Dude, I've been to New Braunfels. Schlitterbahn is awesome. I've only been there once that I remember. I might have gone once as a kid. But I would love to go again. My kids would love that place too. I don't know about the whole like floating down the river thing, but the water park is for the kids. The water park's great. Is the river warm? Because people talk about like floating down rivers in Minnesota and they're cold as fuck. And I'm like, I don't want to do that. Why would I want my ass cheeks freezing the entire time? It's like, well, you can have a cooler with beer and whiskey. I can have a cooler with beer and whiskey at home with my ass cheeks being warm. I don't like this. During cross-examination, Trump attorney Alina Habba suggested Carol had enjoyed the attention received after she accused Trump of rape. Yes, she did, and that's why this shit happens all the time. Questioning Carol about multiple television appearances she made to promote a book in which she first made the claim. There's always a fucking book, isn't there? How well did her book sell? How much money did she make from those appearances? Habba also asked Carol about insulting messages she received in the 5-hour window between when an excerpt of her book appeared online and when Trump issued his first comments denying her allegations, suggesting that such messages weren't merely a consequence of Trump's words. This is actually a bad question. Because she could just say, no, they came in afterwards. And so you have to find a way to imply this without actually asking this question, is my assertion here. And she questioned Carol about interviews she gave in the wake of last year's trial, suggesting Carol reveled in the publicity, which she did. Once I spoke up, I wanted people to know that a woman can speak up and win a trial. Oh, yes, we all doubted it. Women have never won anything related to the Me Too shit. None of them. Actually, not a single woman has ever prevailed in any of these accusation things. They all lose, right? Carol responded, it was a major victory. I don't want to be quiet now. I'm 80. It's not right to make women be quiet. It's been going on for too long. Carol's testimony is expected to continue Thursday, which was today. Just fucking unreal. Like, it's unreal the level of disbelief we have to have about everything to accept any of these comments to accept any of the shit that happens on a day-to-day basis in these courtrooms, to accept the narratives that are spun and breathlessly repeated by the media relating to lawsuits, relating to Donald Trump, relating to specifically women or minorities or anything. Every single fucking time they act like everyone has collective amnesia, and we don't. There's some people with some sort of internalized gender and race guilt that have selective but chosen amnesia. They forget everything that happens intentionally all the time so they can justify their ongoing positions. It's getting a little tiring. But hey, maybe Trump will win his immunity claim through the Supreme Court. Probably not. It should go to them. But again, I keep wondering how the Supreme Court will have enough time in their docket this year to hear all of Trump's cases. And how can they hear anything else? And they have to hear them soon because they all matter now. But we'll see, I guess. All right, guys. I told you it was going to be a shorter show tonight. Like I said, still feeling a little bit weird. So we're going to wrap up. I love you. I respect you. Tomorrow, I'm going to try and find some time to do at least the local stream during the day. We'll see what that looks like. My day is a little weird. And I'm not positive. I'm going to try and go on Eric Hunley's show in the morning also, but we are down a driver. Our nanny is not around tomorrow. She has a day off, which means I have to do driving that I don't normally have to do. So I have to figure out where I have time, but I'm going to try and do that. I'm going to get a little bit more sleep tonight than I've been getting. The past 2 days, I've slept quite a bit during the day. I guess my body's playing catch up, and that's probably why I felt like crap. But going to get a little more sleep tonight because I'm going to go to bed in just a second. And then we'll try and figure out some time to do locals tomorrow, a stream tomorrow night, and then a local stream after that. But we will get this shit figured out and sorted out, and trying to get back to some consistency, but also looking to try some more of the daytime shows at different times and see how those work, because I would love to incorporate those into the schedule. With that, guys, we've got Dallas Guy 98 says, I'll be your nanny. Well, if you're down in San Marcos, it's going to be a while. It's going to be kind of tough. Insert Hurdle 88 says, Rivers, a year-round 72 Fahrenheit goes through the Texas State campus. 72-degree water isn't that warm. Just going to say it. But if you're roasting in the fucking 110-degree Central Texas heat, it could be not that bad. All right, guys. We're going to catch you guys tomorrow. I hope you have a good night. Thanks for hanging out with me. And we'll see you next time. Peace. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some lost-plaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes madder, raging at idiots from Twitter and Erland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an odd bag of Balmore and Lafroig. The spirits blow as the ones who get unemployed. So pour out a glass for the T-Post on Twitter as we hear lost blaming tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all plentiful, from Dante to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. So pour out an odd bag of Balmore at Lafroig. Spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear Lost Planning tonight. From the wide shores of Nairn to the hills of Glenlivet, there's no one who explains the throng better than Nick. So pour out a glass for the ones who have passed.